Many people wonder if they can face legal consequences for biking under the influence in Arizona. The answer isn't as simple as yes or no. Unlike some activities where the law clearly states what's allowed, riding a bike drunk in Arizona falls into a gray area that requires a closer look at how state laws work. If you're someone who enjoys cycling and also likes to have a drink, you need to understand what could happen if you ride a bicycle under the influence. The same goes if you've already been charged with a DUI on a bike and want to know where you stand legally. Arizona law doesn't spell out the rules for cycling under the influence in plain language, which makes it crucial to understand how existing DUI and DWI laws might apply to your situation. Arizona law defines what qualifies as a vehicle in specific terms. This definition matters when determining if driving under the influence laws apply to different modes of transportation. The state considers a vehicle to be any device that transports people or property on public roads. However, the law makes an important exception. Devices moved solely by human power do not qualify as vehicles under this definition. This distinction affects how the law treats different types of bikes. A standard bicycle uses only human power through pedaling. Because of this, regular bikes fall outside the vehicle definition in Arizona's driving under the influence statutes. Electric bikes and motorized bicycles operate differently. These devices use motors rather than pure human power. Since they don't rely on human power alone, they meet the legal definition of a vehicle. This means driving under the influence laws apply differently based on what you ride. You can face charges for operating a motorized or electric bike while impaired. The same laws that apply to cars and motorcycles would apply to these motorized devices. Standard bicycles remain exempt from these statutes. The human-powered exception keeps them outside the scope of Arizona's motor vehicle driving under the influence laws. However, other charges may still apply if you ride a regular bicycle while impaired, such as reckless conduct or public intoxication. If you face a bike DUI charge, several defense strategies may apply to your case. Your attorney might argue that the law enforcement stop was not legal in the first place. If officers had no valid reason to stop you, any evidence they collected might not be usable in court. Another common defense involves challenging whether you were actually impaired. Your lawyer can question the accuracy of field sobriety tests or breathalyzer results. These tests can sometimes produce false readings or be administered incorrectly. The definition of a vehicle under state law often becomes a key defense point. In some states, bicycles may not legally qualify as vehicles under DUI statutes. This technical argument can sometimes lead to reduced charges or case dismissal. You might also prove you were not under the influence at all. Negative test results for alcohol and drugs can support your innocence against biking while intoxicated charges. Getting charged with a DUI while on a bicycle can be confusing. The rules are not always clear, and officers have some choice in whether to arrest or charge you. If you face these charges, you need to talk to a criminal defense attorney right away. A DUI lawyer who has handled similar cases in your area will know how local courts work. They understand the specific laws that apply to bicycles in your state. Having legal help makes a big difference. Your lawyer will answer your questions and guide you through each step of the process. Contact the criminal defense team at 602 900 9891 to schedule your complimentary consultation.